Good morning, everyone, and welcome. We're going to ask Mr. Minges to read the docket, please.
Thank you, Mr. Chairman. Good morning. This proceeding in docket number 2017-292-WS concerns a petition for reconsideration regarding Riverkeeper litigation expenses. Mr. Chairman, the docket's in order.
Thank you. Okay, we'll take appearances. And make sure you get by the microphone because we don't want anybody to miss it out there.
Chairman, members of the Commission, Frank Ellerby appearing for Carolina Water Service. That name has changed now to Blue Granite. We've continued since this is, I think, the last proceeding in the 2017 rate case. We've continued to refer to the company as Carolina Water Service just to avoid confusion. So I will continue to do that today. Thank you.
Thank you, Mr. Ellerby. Good morning. Punch that button.
Does it work now, Mr. Chairman?
Your own.
Good morning. My name is Stephen Ham, and I serve as counsel for the Office of Regulatory Staff. And as Mr. Ellerby just said, during the course of my argument, I am going to make reference to Carolina Water Service because all of the pleadings in this matter reference it, but we are aware of the new name of Blue Granite. Thank you, Mr. Chairman.
Thank you. Ms. Valtorta, you punch that button, please, ma'am. There you go.
My name is Laura Valtorta, and I represent the 40 Love Point Homeowners Association.
Thank you, ma'am. And Ms. Valtorta, I understand you're not going to be arguing, is that?
I'm not making an argument, no.
Okay. Thank you. Okay, anything preliminarily, I got that word out, that's a hard word for me, that we need to do before we start? Mr. Ellerby.
Thank you, Mr. Chairman. The issue that we've asked y'all to review and that y'all have agreed to rehear and reconsider is the issue of the treatment of the litigation expenses incurred by CWS in defending Riverkeeper litigation that was initiated in January of 2015. And you initially, in the first order in this case, in the rate case order, the Commission allowed the recovery in rates of these litigation expenses amortized over an extended period of time. ORS asked for reconsideration of a number of issues, and this is an issue that the Commission decided that it would reconsider and decided not to allow recovery of the Riverkeeper litigation expenses. We then asked y'all to reconsider that, and that's what we're here today to talk about. The specific issue involved in the Riverkeeper litigation has proven to be an extremely difficult issue under the Section 208 of the Clean Water Act. And that is that Section 208 requires states to come up with regional plans. An important aspect of those regional plans is the elimination of smaller discharges and the incorporation of the flow that treated by those smaller facilities be incorporated into regional facilities. And that's the CWS I-20 plant had a permit from DHEC, a discharge permit under the Clean Water Act that allowed them to discharge but required CWS to close down that facility and interconnect when regional facilities became available. And that issue of when the regional facilities become available is an extremely difficult issue. We would ask y'all to, since we filed our petition for reconsideration, this commission addressed a similar issue in the Duke Energy Progress rate case. In your initial order, you disallowed recovery of litigation expenses associated with certainteed litigation between DEP and certainteed. we asked for reconsideration on a number of issues, and y'all agreed with us. We don't have a final order on reconsideration, but we do have an order, a directive that this commission issued in the in the DEP rate case. And the reason I bring that up is, to my knowledge, that's the most recent ruling by this commission on a similar issue of how do we look at litigation expenses by a regulated utility, and under what circumstances is it appropriate for the ratepayers to pay for those expenses as part of the company's cost of doing business. And what ORS argued in the DEP case is similar to what they're arguing now, a very narrow focus on the litigation. And the result in that case, DEP had settled the certainty litigation and paid some money, and ORS's position was that settlement didn't benefit ratepayers and therefore shouldn't be recovered from ratepayers. On reconsideration, this commission took a broader view of the whole contract with certainty and determined, and what y'all said was based on the entire contract, there was a net benefit in that contract to ratepayers of $50 million, even after you pay for the expenses and pay to settle the case, and therefore there were benefits looking at it broader. That's what I'm asking y'all to do today with respect to the Riverkeeper litigation, is to take a broader view, not just focus solely on the outcome of the Riverkeeper case, although we've now settled it, and I want to tell you about that also. But as we take a broader context, there are two South Carolina Supreme Court cases that are very important that deal with this issue. The first one was City of Columbia versus DHEC in 1987. In that case, the City of Columbia objected to DHEC requiring it to acquire and close down some smaller discharges, and the Supreme Court said, City of Columbia, you took on the responsibility under the 208 plan as the designated management agent, and it's your responsibility to follow through and to take over those plants and to close down those discharges. The second case was Midlands Utility versus DHEC, and there were several issues that the Supreme Court ruled on in that case, and this one was 1993. But one of them that I think is critical to this proceeding is the court found that the circuit judge had committed an abuse of discretion by affirming a fine that DHEC levied against the utility, Midlands Utility, because Midlands Utility found itself in the same position that CWS was in with respect to the I-20 plant. Midlands Utility could not interconnect because the City of Columbia wouldn't interconnect with them, and Midlands Utility couldn't upgrade its facilities so that it could enhance its discharge. So it was stuck in that situation where they couldn't upgrade, couldn't interconnect, had violations, and the court said those violations were the fault of the City of Columbia for not interconnecting with Midlands, not allowing Midlands to interconnect, and reversed the fines as an abuse of discretion. Those two cases together show that the South Carolina Supreme Court, under the Clean Water Act, put the obligation obligation to eliminate these discharges, like the CWS discharge at I-20, in the responsibility in the hands of the local governments who operate the regional facilities. In our view, that's the town of Lexington. The third thing, that going back, some history here, is this commission's order number 2003-10 in docket number 2002-147S, which is the order by which this commission refused to approve a contract between the town of Lexington and CWS that would have, back in 2002, would have allowed the closing down of I-20. The contract was negotiated between CWS and the town of Lexington that would have allowed the interconnection, but this commission found that the rates were unfair to those customers of CWS that would be served as on a wholesale basis by the town of Lexington and refused to approve the contract. So we have South Carolina Supreme Court cases saying it's the local government's obligation under the 208 plan to take responsibility for seeing that these smaller facilities are closed down. It's the CWS and town of Lexington approved, entered into a contract. This commission rejected it. CWS was, in our view, CWS was doing what it was supposed to do. Following that failure, after this commission rejected, CWS continued to make efforts to interconnect with the town of Lexington. Exhibit C at the rehearing of this case, Exhibit 7, can't read my own handwriting, the rehearing of this case last fall, the company put in one exhibit, a compilation of correspondence between CWS and the town of Lexington that showed that CWS continued to inquire of the town of Lexington about capacity and about the ability to interconnect on October 2011, July 2013, and March of 2014. So CWS continued to make efforts to interconnect with Lexington. In the view of CWS, it was Lexington's responsibility, as held by the South Carolina Supreme Court in those cases. So it was the responsibility of Lexington to find a way to make that interconnection happen, or, as they have eventually done, to condemn the facility and take it and incorporate it into the Lexington system. The town of Lexington did not do those things. Riverkeeper brought the action in federal court in January of 2015, and what I think y'all should determine is that, so CWS is now defending that case with that backdrop of South Carolina Supreme Court saying it's the municipal entity's responsibility to see to it that the interconnection happens, as it did with the City of Columbia. You've got this commission having turned down a contract because the rates were inappropriate and unfairly established. And so the reasonable, prudent, and appropriate, unavoidable thing for CWS to do was to defend the litigation. There was nothing inappropriate or imprudent about what CWS did in defending that litigation. It had appropriate legal basis that said that CWS was in the right place on those issues, given what the South Carolina Supreme Court had held. And CWS did defend the case. Now, they got as y'all are aware, got an order from a preliminary summary judgment order against them, finding violations. But that is not the end of the discussion. As this commission ruled in the DEP rate case on the certainty litigation, in that case, there was a preliminary ruling against DEP. While it was on appeal, it was settled. Exactly what happened here. There was a preliminary summary judgment ruling by Judge Seymour against CWS, finding CWS was in violation of its permit by not having interconnected, not having closed down the facility by interconnecting it. But before that decision could be appealed and become final, CWS and the Riverkeeper entered into settlement negotiations, and the case was settled. We have submitted as a supplemental exhibit to this commission, and it's agreed upon by the ORS, and it has been, as part of y'all's order, you've indicated that the supplemental exhibits about the settlement will be part of the record on this in this proceeding. The settlement is very valuable and beneficial to ratepayers, we submit. There are two other facilities, Friarsgate and Watergate systems, that are in a similar situation to the I-20, in that their permits also require them to be closed down and interconnected, one with town of Lexington and the other with the City of Columbia. And the Riverkeeper has agreed as part of the settlement that the Riverkeeper will assist in CWS efforts to enter into interconnection agreements to eliminate those discharges. And we think that is extremely helpful. Riverkeeper has a responsibility of trying to advocate for full implementation of the 208 plan, the elimination of these discharges, the improvements of the rivers in the Midlands, and their voice is an important voice, and we believe that their support for the effort to enter into appropriate interconnection agreements that can be approved by this commission or acquisition by the entities, the town and the city of Columbia, if interconnection can't be done, that's the appropriate way for this to be handled. When it stays in limbo for years and years and years, it's the responsibility of the entity, the town or the city that is the designated management agent who has that responsibility. That's what the South Carolina Supreme Court held. We think the Riverkeeper's assistance will allow the company to enter into interconnection agreements with respect to those other facilities that will avoid this expensive litigation, will allow and therefore be beneficial to ratepayers by allowing service to continue uninterrupted. All of this activity by the company throughout this litigation has been unavoidable. I mean, the company couldn't stop the I-20 facility, couldn't shut it down without interconnecting it. It couldn't interconnect with the town of Lexington without an agreement. It can't operate under an agreement with the town of Lexington for interconnection without that agreement having been approved by this commission. The company really did not have a easy way out of this situation. It litigated. It's my understanding that ORS has not taken any issue with the amount of the litigation expenses. That ORS simply says, well, you had a finding from Judge Seymour that you were in violation of your permit, therefore no recovery. We think it's a lot more complicated than that. We think that the way this commission approached the certainty litigation issue with respect to the DEP rate case is the right way to approach it. And when you put the conduct of the company in the context of how difficult the 208 situation is, and the difficulty that other entities like Midlands Utility and City of Columbia have had to deal with these situations, you'll understand that CWS behaved appropriately, prudently, and that its reasonable and necessary litigation expenses should be included in rates. So I thank you for your attention. I'm glad to answer any questions. I'll turn things over to Mr. Ham.
Thank you, Mr. Ham. Let's cut your mic on.
Can you hear me now, Mr. Chairman?
Get closer. Probably be better if you cut it back off, but it might be better if you get at the podium. We just want to make sure we can hear you and that they can hear you out there worldwide.
Now is it on? Well, I'm very happy to know I'm officially on. Good morning again. I'd like to offer a different perspective and sort of ask the commission consider, and I will agree with Mr. Ellaby that you need to look at it in several different perspectives. But I think the various perspectives do not and should not result in ratepayers paying for the litigation costs of the company defending a lawsuit where the allegations were that it violated the Clean Water Act. I'd like to give you a little bit of perspective. It won't take very long. My argument won't be much longer than Mr. Ellaby's. The Clean Water Act was enacted by Congress initially in 1976 to begin a program of cleaning up the nation's waters. One of the primary thrusts of that, and if you'll look in the purposes section of Title 33 in the United States Code, you'll see that they were intending that the nation's waters would over time be cleaner and protect the interest of citizens and the use of water both for consumption purposes and recreation purposes by creating these regional treatment systems. In 1991, Carolina Water Service got a permit to operate the I-20 plant. They got a temporary operating permit with the express condition that at some point they were going to have to interconnect with the regional system. I don't think Mr. Ellaby and I are not in conflict, I think, at that point. We're becoming conflict, and I think it's notable that in the pleadings and materials submitted on Carolina Water Service's behalf, they essentially ask you, well, just ignore what the federal court order said and look at all these other things. And I'm going to suggest that that is a dangerous thing for the commission to do. Let me start with a premise. This commission has made it a practice of my 40-plus years in front of it that you have not authorized regulated utilities to recover fines and penalties that have been imposed based on allegations and ultimately rulings that the utility involved violated their operating agreements. In fact, your own regulations expressly state that you expect them to meet their operating conditions under any other entity responsible for regulating their conduct. For example, DHEC in this particular situation. DHEC is under the 208 plan of the Clean Water Act. They are the state's agency that implements and monitors compliance under those 208 operating plans. Step back, and I want to start with this overview, and then I'm going to go through the details. I'm going to suggest that some of Mr. Ellaby's arguments and citations to case are not relevant to the conduct the Carolina Water Service engaged in the course of this particular litigation. But let me start with this. If ratepayers are not going to be burdened with fines and penalties, which were paid in this case, should ratepayers be burdened with paying for the legal expenses when the company ultimately had a federal court issue a ruling of liability? And I'm going to talk about the settlement agreement, and I'm going to suggest to you that the settlement agreement cannot be and should not be used by the commission as a device to obviate a policy that ratepayers are not going to be burdened by fines and penalties. Columbia Riverkeeper is an organization authorized under the law to bring various actions. You heard the testimony of Mr. Stangler during the course of one of the proceedings, and he testified that they didn't start off, or they weren't focused on Carolina Water, but they started looking at the federal regulatory records at DHEC for purposes of discharge, and they saw multiple violations of their discharge permit. Not one, not two, not three, 23. Now, quite honestly, I think that's enough. There was no dispute. Ultimately, the discharges recorded at DHEC reflected discharges that exceeded the effluent limitation standards of their operating permit. Done, set, and over. So why would any aspect of the attorney's fees, where in fact those discharge limitations were exceeded, why would any aspect of attorney's fees be paid for by ratepayers? In fact, I think, and I argue to you this moment, that alone, forget about interconnection, that alone suggests that violation took place. In the face of that violation, ratepayers pay nothing. Now, in 1991, they got this temporary operating permit. Now, you recall in the record that ultimately Carolina Water Service made an effort and said, well, we want to avoid, and I'm stating this as a fact, there's no judgment here at all. We want to avoid the obligation of having to interconnect. We liked operating our own system. We want to maintain the value of our own rate base. And they went and sought to be named as the permanent operator of the I-20 treatment plant so that they would be free of the obligation to interconnect. Well, number one, that's directly opposite of the standards contained in the purposes section of the Clean Water Act, and that effort was denied. You heard testimony, and I want to make sure timing is an issue here. You heard Mr. Stangler testify, and the documents in front of you confirm, under the Clean Water Act, a party can bring an action. They just can't go walk down to court and file something. They have to give notice that an action is coming. Under the Clean Water Act, that notice time period is 60 days. 60 days. But in this case, Congaree Riverkeeper waited well over a year. Mr. Stangler said that was going to give them time to sort of get their act together. And at the time they ultimately filed, they still had not interconnected. The case went before in district court for Judge Seymour. I feel very comfortable in saying a highly regarded judge in this state, and a highly contested proceeding, certainly understandable. For those of you on the commission that are not lawyers, a judge issuing an order in summary judgment is actually quite remarkable, because under the standard of the law, there have to be no remaining dispositive facts that are not in dispute. The judge concluded that there were no remaining disputed facts, and she had the obligation and at least took the responsibility for issuing an order finding liability on summary judgment. Summary judgment is hard to get. It's always easy for a judge, and I look at Judge Irvin, and having stood before him a few times in my career, it's always easy to deny summary judgment, because that's not appealable. He said, well, there's going to need to be a proceeding. But Judge Seymour took the extraordinary step of saying, based on the facts and evidence presented, I am in a position where I can issue a ruling on liability. Judge Seymour addressed some of the points that Mr. Ellerby made in the course of his argument to you, and I want to caution you not to ignore, as is suggested, the discussion that Judge Seymour entered into in finding summary judgment, which again, as a legal remedy, is somewhat remarkable. I have gotten summary judgment a few times, but not very many times. There was times when I thought I ought to get it, and some people, including somebody in this room, said, no, Mr. Ham, you're not that good at this point, and denied it. But on a more serious note, the judge, there really wasn't much that Carolina Water Service could say about the 23 violations, other than, the recorded effluent discharges records at DHEC reflected that the discharges were not in compliance with that National Pollution Elimination Discharge Permit. 23 of them. And she rendered a penalty of $23,000, $1,000 a penalty. Even more remarkable, and again, I invite the commission's attention to that order simply in fairness to each of you, that you go, all right, well, Carolina Water Service wants to recover the legal costs where they're defending and they ultimately paid either fines and penalties or the direct equivalent to them. And Carolina Water Service says, well, we were defending a case alleging violations. The district court found violations, and they say, we have a brilliant idea. No, we won't ask for recovery of the fine and penalties. We'll just ask for ratepayers to pay our legal fees for our non-success in federal district court. Well, if you've got a principle, and Carolina Water Service and others say, oh, no, you have no principle that if somebody violates, a regulated entity violates the law, that you don't recover fines and penalties. Well, then this is going to be the time when you're going to have to say it. There is no question in this circumstance. Federal District Court identified a specific penalty dollar amount for the 23 effluent discharges, $23,000. The Federal District Court heard the same arguments that this commission has heard about how diligent and faithful they were with their obligations. The Federal District Court said, based on the evidence and the facts, she concluded that Carolina Water Service did not engage in good faith actions. As Mr. Stangler testified in front of you, Carolina Water Service's problem was if they didn't get exactly what they wanted, they weren't going to do it. Now, remember I told you that under the Clean Water Act, Congaree Riverkeeper had to give 60 days notice. Carolina Water Service had over a year to sit down with Congaree Riverkeeper and said, please help us get this interconnection going. They didn't do that. And what did they argue in front of Judge Seymour? They argued that they had no obligation. Well, in fact, what she found is they had an obligation to act in such a way to facilitate reaching agreement. And Mr. Ellaby pointed out, one of the things I was going to point out to you, this commission has run into this situation. And in the 2002 decision, what you objected to was, well, they entered an agreement, but they wanted ratepayers to pay way, way too much, and we're not going to approve it. That's a two-way bargaining street, and you all said, no, you better come up with a better deal than that. Well, they didn't come back to you with a better agreement. And the finding of the Federal District Court that there was an extended period of time in which there were communications, but the communications were not designed to achieve an interconnection agreement. And again, during this entire period of time, Carolina Water Service had the ability to sit down with the Congaree Riverkeeper and say, please help us. You put us on notice you intend to file a lawsuit. Sit down, talk with us. But their whole argument in district court wasn't, we're trying to figure out, well, it doesn't apply to us. And they tried to argue that Congaree Riverkeeper didn't have standing. They didn't show any injuries. Congaree Riverkeeper responded, well, here's the affidavits of individuals that used the Congaree River and talked about the smell, the objects of effluent particles in the water that could be seen, and that alone constituted damages for purposes of allowing them to proceed as plaintiffs in their action against Carolina Water. Okay, now, Congaree Riverkeeper files their suit. They don't hear word one from Carolina Water Service during that period of time. Don't hear them say word one. So they're now saying, oh, well, they've got this great benefit. They got the supposed benefit because Carolina Water Service took actions that required the Congaree Riverkeeper to either vindicate their rights or not. What I think is very interesting, and I as someone who has high regard for the commission, recognition of your heavy responsibilities, and wanting you to make decisions that reflect an ongoing commitment to your regulatory principles and your efforts to balance various issues. The federal court found liability, and they were, not surprisingly, they said, wait a minute, you want to impose a $1.5 million penalty for our failure to act in good faith and connect. That's essentially what the court found. And the court said, I tell you what, I am going to set aside the penalty provision of the court's order, the $1.5 million. And I'm going to set that aside and allow the parties to have an opportunity to brief and present oral argument to the court so that Carolina Water Service will have full due process rights of articulating why $1.5 million isn't appropriate or whatever. And the court, created that opportunity. Shortly thereafter, the parties asked Judge Seymour to name a magistrate to serve as a mediator in that matter, Magistrate Baker down in Charleston. It's my understanding they had a couple of meetings working towards some sort of an agreement, and ultimately the parties entered into the settlement agreement that now appears before this commission in this record. What's important about that settlement agreement? The settlement agreement acknowledges that the court found liability on the causes of action brought by the Congaree Riverkeeper. But it goes on to say, to be fair, Congaree Riverkeeper says, well, we certainly don't agree we violated the law. Well, of course, it's a settlement agreement. The question to the commission is, they could say they won if they walked in here and said, here's a federal court order in which Congaree Riverkeeper failed to prevail on any of their causes of action. That did not happen. That did not happen. And they're now trying to say, well, because we entered into a settlement agreement, and the settlement agreement has Carolina Water Service saying, well, we don't admit to anything. And again, I've never seen a settlement agreement with a defendant that didn't contain that kind of language. And what ultimately came of that? Let me talk about a revision of the Clean Water Act that I think is important. Did the Congaree Riverkeeper have any entitlement to recovery of its legal fees? Under 33 U.S.C. 165D, 1365D, the Congaree Riverkeeper would only have an entitlement under the law, if approved by the court, if they were the prevailing party or substantially prevailing party. Carolina Water Service paid Congaree Riverkeeper's legal fees of $385,000. They didn't pay those legal fees because they thought, well, we're just going to be kind and generous this morning. We're going to go ahead and pay your legal fees. They paid those legal fees because the statute authorized the recovery of those fees only if a party is a prevailing party. The settlement, I believe, acknowledges that, in fact, the Congaree Riverkeeper was a prevailing party. And again, forget about interconnection for just a moment. They violated the law 23 times. The court said the penalty is going to be $23,000. The settlement agreement references that Carolina Water Service would pay $23,000. Where did that number come from? That number came right out of the Federal District Court summary judgment order finding a penalty, requirement of a payment of $23,000. What it appears that we're entering into, and I'm going to address the other issues, but can a settlement agreement be used for purposes of convincing this commission that ratepayers ought to pay the legal fees of a company defending fines and penalties, which they ultimately paid? They paid a total of $763,000, $28,000 in fines to the federal treasury, which is the record reflects has been paid. They paid $350,000 to the Central Midlands Council of Governments for programs dealing with the Section 208 plan and water discharge related matters, and then the $28,000. I was reading the transcript in this particular proceeding about the attorney's fees. I want to start off by saying the commission should not decide the issue of whether or not ratepayers are going to pay attorney's fees based on the dollar amount. I think it'd be real hard. I think it makes it different. I don't think it changes the principle if they were seeking $10 million. Ooh, no, we're not making ratepayers get burdened with $10 million in attorney's fees. What if they were only $10,000? Does only $10,000 change how this commission applies its policies and principles? It shouldn't. Your policies and principles ought to be applied in a consistent manner regardless of the dollar amount. Now, there's been, in the proceeding, again, I'm trying to make sure I'm scrupulous for the facts. I think Mr. Ellaby was attempting to do exactly the same thing. Mr. Howard, in the transcript I was reading, in preparing for this argument, you asked a question, well, how do I know that a particular fee was reasonable, whether it ought to be 700 hours, 500 hours, 400 hours? And the answer then is the same as the answer today. You don't get to that unless you believe that ratepayers ought to pay the attorney's fees where a company has been imposed fines and penalties of $763,000. Every step of the way, the client that the attorneys for Carolina Water Service were representing were not ratepayers. They were never going to pay, under your rules, they were never going to pay the $1.5 million penalty. They were never going to pay the $28,000 penalty paid to the federal government. They were never. And I think if you go there, then the corollary is, and we're not going to let you get indirectly, which we never allow you to get directly, attorney's fees of $385,000. But you all are going to answer that question in this proceeding. Now, let's talk about the conduct of Carolina Water Service. It was interesting, and they make the comment, well, we had to defend the lawsuit. The phrase that came to my mind, they said, well, this was sort of just a drive-by lawsuit out of the blue. No, it wasn't. If you got 23 affluent discharge violations, you can certainly expect DHEC or somebody's going to come after you. It's not like they were sitting there pristine and clean. They weren't, because they already had those violations. And even in the materials on reconsideration, in the reply of Carolina Water Service to ORS's opposition to petition for rehearing and consideration, on page 4, Carolina Water Service acknowledges that they were obligated to connect with Lexington, that they were obligated. Now, he made reference to some cases. Those cases, I don't think, have direct application in this circumstance. In the Midlands Utility versus DHEC, that's not this kind of circumstance we're facing here. They said that the court had abused its discretion in imposing a penalty, but that went to a different kind of conduct. I think that case is being rather loosely applied, and we would argue respectfully that the commission, that is not a controlling case. What you're now confronting, I'm looking at my notes of his other part of his argument. This commission has already acknowledged, and I would remind the commission, because I think it serves as part of the foundation to deny the request here, you didn't believe in 2002 that the company had come before you in good faith. They entered into an agreement with rates you thought were totally inappropriate, not in good faith, and you turned them down. You've already confronted that, and the reason they encountered that situation, that they agreed to rates that were too high. So you have already been a part of and been exposed to some of the conduct during the interim period. Okay, finally, where are we now? I was interested that Mr. Ellaby brought the Duke case into this case, so I will happily step into that and offer what I believe is a different perspective. In the certainty cases, you'll recall the company's coal plants, in the course of their operation, create synthetic and I'm now drawing a total blank. Anyway, that's picked up in the scrubbers. And Certainty could use and wanted to use that material as part of their operations in terms of making various products. And you'll remember in that particular circumstance, they started negotiating an agreement in 2002. They negotiated a couple of times, entered into another one in 2008, and then in 2012 they entered into a final agreement. And it was only at that point actually that Certainty began operations, because they had built a plant literally next to the Duke coal plant in order to facilitate immediate and inexpensive delivery of those materials directly from the Duke plant to the Certainty operation. In that particular case, Duke messed up, didn't do calculations, and couldn't even meet the terms of its agreement. What was compelling to us, and apparently it was not compelling to the commission, but I'm still going to argue that it is, the North Carolina Business Court concluded that the arguments made by Duke were not sustainable based on the documents presented. And in fact, the business court references a witness in that proceeding that the court found totally having no credibility. That same witness testified in front of you in this proceeding. And our position was that if they don't even understand the terms of a contract, the business court found that that's their responsibility, and any losses shouldn't be paid for by ratepayers. There's no question on reconsideration you all concluded that you were going to allow them to proceed, and that is under reconsideration. But I think that is an entirely different circumstance than here. So I wanted to make sure that I expected Mr. Ellaby to raise it. I expected that he would, but I believe that that circumstance is not equivalent to what is in front of this commission today. So ultimately, where are we now? Do you have a policy where ratepayers don't pay for fines and penalties? I think the answer is yes. But do you have a policy that says ratepayers are going to pay for their legal fees when they ultimately have to pay $763,000 in fines and penalties? And our answer is no. The principle being the commission should not approve collection indirectly, which you would not apply directly. Why would ratepayers be stuck with the legal fees where there was a violation? Court's federal district court order says that the settlement agreement does not obviate, eliminate, disguise, or in any way change the fact that the federal district court found liability. The question now is, does a settlement agreement change your idea of whether or not ratepayers ought to pay for it? So in closing, we simply say, please make sure if you have policies and principles, apply them consistently, and don't allow a regulated utility to collect indirectly what you won't allow them to correct directly. If they shouldn't pay for the fines and penalties, why should ratepayers pay for the legal fees in which they were unsuccessful in getting a verdict for the defendant? That didn't happen. And for that basis, we think it's inappropriate. And again, I don't care if they were seeking $10,000. The dollar amount doesn't change. It'd be easier for me, quite honestly, if they were trying to run $10 million by you. I think you might have a natural inclination to say, wait a minute. But our position is the dollar amount should not change how you approach it, because if you have a policy, apply it consistently, and it falls out wherever it falls out, but you all stand on the high ground of consistently applying your principles. Therefore, we respectfully ask this commission to not grant reconsideration and give Carolina Water Service recovery of legal fees It's inappropriate, it's not consistent with your policy, and I can't imagine what it is you would tell a member of the public or a news reporter, well, Mr. Commissioner X, why are ratepayers paying the legal fees for the company when they lost? Well, if you're going to do this, you better think about what the answer is. And my easy, helpful response to the commission is don't put yourself in that situation in the first place. Thank you very much.
Thank you. Mr. Ellaby.
Thank you. Thank you, Mr. Chairman. I'll try to respond to a few points that I need to respond to. First thing is, we're not arguing that the settlement by itself is the reason that you should reconsider your ruling. We filed the petition for reconsideration on this issue prior to the entering into the settlement. We think that's an additional reason that that you should find in favor of CWS on this issue. But we believe that, as I tried to make clear in my initial argument, that the company was relying on South Carolina precedent. And that's the importance of the Columbian Midlands utility cases that I talked about, that the South Carolina Supreme Court had said the primary responsibility for getting this interconnection done and eliminating these discharges is with the entity that takes on the obligation of being the designated management agent under the 208 plan. That was Town of Lexington. Town of Lexington's responsibility for seeing that the interconnection get done. Town of Lexington did not make its facilities available. The case was about, the Riverkeeper case, yes, there were effluent violation fines, similar to those in the Midlands case, a Midlands utility case that I talked about, where because the company couldn't upgrade its facilities, it continued to have violation problems. But the focus of the case was on, as Mr. Stangler agreed, the relief that was requested by the Riverkeeper was a shutdown of the I-20 facility, which could not have been a good thing for customers of CWS that are served by that facility. So that was the focus of the litigation. It wasn't the 23 violations. It was the effort to shut down that facility, and it was the primary responsibility of the management agent under the 208 plan, Town of Lexington. And therefore, CWS efforts were reasonable, and its defense of the case. Now, Judge Seymour arguably had a different view of whose responsibility it was, but it cannot be the case that when CWS defends that case, relying on established precedent from the South Carolina Supreme Court, saying that it's primarily the Lexington's responsibility, it can't be unreasonable to defend the case relying on that precedent. May
I ask a question?
Absolutely.
Mr. Ellaby, did Lexington, the city of Lexington, sue you as well?
They sued to condemn the facilities while this was going on.
But the action and before Judge Seymour,
Town of Lexington was not
a party.
No.
So doesn't that undercut your argument? You weren't defending the Town of Lexington's suit. You were defending the Riverkeeper's suit.
Absolutely, Commissioner Irvin. But in my client's view, the Riverkeeper should have brought in Town of Lexington, and it's my understanding there was a point where CWS tried to get Town of Lexington added as a party to the case, and that did not succeed. But my point today, for purposes of evaluating the conduct of the company in defending the litigation, is that I'm not here criticizing Judge Seymour's decision or her opinion. I don't agree with it, but that's not the point of my argument. The point is, at the time the case was brought and leading up to the case being brought, CWS had rulings of the South Carolina Supreme Court that were consistent with the position that it was taking, which is, Town of Lexington, it's your obligation to find a way to get this interconnection done. In that connection, I don't mean.
No, that's okay. You could have brought the town of Lexington in as a party, couldn't you?
It's my understanding that that effort to substitute the town of Lexington as a party was not successful. I don't know exactly what transpired with that. I was not involved in that case.
But ultimately, Judge Seymour found in her ruling that River Keepers was entitled to a judgment since there were no material issues of fact.
She did grant summary judgment.
And
yes.
so you lost the case. And I guess I'm having a very difficult time understanding why the ratepayers should be responsible for that loss.
Well, I don't believe that.
If you'd won, I think if you'd have successfully defended, I think we'd have a whole different situation. But you lost.
But the this commission in this case also allowed the company to recover fees and expenses associated with another case that it brought that it lost. The DEP case, one reason I mentioned that was because, as Mr. Ham told y'all just a few minutes ago, there was a business court decision against DEP, and then there was a settlement. This commission looked more broadly at the full context of that gypsum contract and said, we think this was a reasonable decision and it was beneficial to ratepayers. Mr. Commissioner, I don't believe it's the case that whether you recover based on whether you win the case or lose the case.
Well, let's follow that, trying to follow your logic. Why was it beneficial to ratepayers to settle the case on the gypsum?
Because what the commission's order on reconsideration said was that there was that contract itself that permitted, instead of burying the gypsum, burying the byproduct of the scrubbers, allowed it to be sold, was very beneficial to the ratepayers over the life of the contract. It had a provision in there that was disputed as to whether the company, when natural gas prices, as you know, unexpectedly came down and coal plants were out of the money, they stopped producing nearly as much gypsum. So they were in a difficult situation. They made a business decision to pay liquidated damages and get out of the contract. And this commission appropriately said that was a good contract, even if you ended up losing that litigation, and we're going to permit you to recover.
And the business decision they made was in the best interest of the ratepayers.
Absolutely.
But here, we have an entirely different situation. That was a contractual matter. This is a violation of the Clean Water Act.
But this is a company that was in the position of operating, as Mr. Ham told y'all a couple of times, a temporary facility. It couldn't upgrade and invest a lot of money into a facility that at some point in time had to be eliminated. So the company tried its best to get an interconnection agreement in place with the town of Lexington. And I'd like to take that opportunity to address a point about the 2003 order from a 2002 case by this commission, in which this commission refused to approve the contract that had been negotiated between CWS and the town of Lexington. And there is no finding in that order that this commission found that CWS had acted in bad faith in negotiating that contract. Instead, I'm reading from page 13, the commission's order said, thus the agreement includes a rate which is in direct conflict with and contrary to the commitment made by the town of Lexington in 1993, namely that the town of Lexington would not charge existing customers for the cost of a regional system. I think if you read the order, I think this commission put the blame for the terms of that contract being unfair at the feet of the town of Lexington. That it was Lexington, by asking for too high a cost in that contract to be put on CWS customers, it was the town of Lexington that failed to get CWS system that interconnected so that the I-20 facility could be eliminated. And that was the company's experience. The company's experience when, in 2015, when it was defending the case, in 2014, when it got notice from the Riverkeeper, we're going to bring this case, the company had said, well, here's what the South Carolina Supreme Court has said, and here's what the Public Service Commission said. We need Lexington to give us, to make, first of all, to say that the system is actually available. The town of Lexington took the position at different times, and this is all in the record, that there wasn't capacity and that therefore they couldn't make the facility available to be interconnected. And then Judge Seymour didn't agree, and we acknowledge that, but I think you will see, and we've cited it in our memorandum, some of the findings that she made about the company not making efforts to interconnect are contradicted by correspondence that's part of that Exhibit 7 that was submitted to y'all. And you're absolutely free to make your own findings. I think you have a responsibility to make your own findings and see that that the judge was wrong about the company failing to make efforts to interconnect with the town of Lexington.
Well, let's assume that, that they did make efforts, and that, I'm sure that's substantiated by the correspondence that you're referring to. Let's assume that it is. It still doesn't justify all the discharges in violation of the Clean Water Act by your client, right? I mean, you can't really justify that. So, well, we're really trying to interconnect with the city of Lexington, but we're going to continue to discharge in violation of federal law.
Well, and this is one of the most difficult issues in the whole area, and it was discussed by the South Carolina Supreme Court in the Midlands utility case. When you have a temporary facility that at some point you have an obligation to shut it down, if you want to upgrade your facility and go to a tertiary treatment system, which would eliminate the violations and you'd get a better discharge, you've got to spend millions and millions of dollars to do that, to put that facility in place. Then, if a couple of years into depreciating those expenses and recovering them in rates for that investment, the regional system says, well, now we're ready to take it. You potentially have a stranded cost issue, which this commission would have it would be a very difficult situation. So there's a reason DHEC hadn't done anything about those violations, and the reason is DHEC knows that the utility is in a quandary there, because on one hand we can't upgrade, and on the other hand we can't interconnect because we can't get the local government to cooperate with the interconnection. That's what the City of Columbia cases were about, that the Supreme Court decided. Of course, CWS was very familiar with that and believed that the primary responsibility was on and I'm repeating myself, but I'll try to wrap it up. The primary responsibility was in the hands of the designated management agent, and therefore it was reasonable to defend the case the way they did. And I think I have responded to the points Mr. Ham raised that I intended to respond to.
Mr. Chairman, I have a quick question for counsel, if I may.
Yes, sir. Yes, sir.
Mr. Ellaby, let's assume that the commission take your position. I'm just curious as to how did the town of Lexington get away? It seems they would have some liability in not working with the company regarding interconnection. Is that a fair statement? That's
certainly the way we see it.
Okay. So how did you let them get away? Or how did the company let the town of Lexington get away?
Well, there's now been a condemnation case that was tried a couple of weeks ago, and the town of Lexington, a verdict was entered. That case is a long way from being over, but based on the post-trial motion that the town filed contesting the award and rulings during the trial, I don't think the town of Lexington is very happy with the award, and I don't think they may not see it that they've gotten away with anything. So,
But that particular case doesn't or won't have any effect on the ratepayers.
it will not have an impact on the ratepayers. No, but it was an alternative, and that's part of the explanation, or part of the reason why the responsibility is appropriately placed on the governmental entities that are the designated management agents and have these regional facilities. They actually have the power to condemn these facilities, and as Lexington did in this case. So,
Thank you.
thank you.
Okay. Mr. Ham, I'm going to give you a chance to respond, and then we'll take more commissioner questions.
This commission is going to make a decision based upon the record before you, and I want to be very careful what I say, because I don't agree with a lot of what Mr. Ellery said, but some of that is outside the record. So let me go back to what's in the record to help you, Commissioner Williams, maybe have a perspective. What the federal district court said was, yeah, Carolina Water Services was having contact, but they really didn't want to interconnect. They wanted to keep that plant on their own system, and they never really put themselves in a negotiating position designed to actually result in an interconnection. So that's part of the reason the court found the lack of good faith. Town of Lexington all along, and we've all along had the ability to file a condemnation proceeding. Quite honestly, I think in terms of my view, my focus is federal district court says they're not acting in good faith. They heard some of these exact same arguments, and Judge Seymour did not conclude that they rose to the level that justified a lack of interconnection when in fact the Clean Water Act is a strict liability statute. She said in her order referencing this commission, you all set out some standards to give them some guidance about what you would approve and wouldn't approve, and the record doesn't show any effort they attempted to do that. Again, I just point out, Congaree Riverkeeper only had to give them 60 days notice. They waited over a year, and they still hadn't engaged in the kind of good faith negotiations to move towards an interconnection. That was a fundamental part of the federal district court order, and it's because of that that we object to ratepayers paying for it. But there's an adage, and as a good lawyer, you can't make decisions but based on surmise, conjecture, or speculation. And I have some great ideas to surmise, speculate, and provide conjecture to you, but I don't think I can properly do that. And I think that would be required for me to answer your question, because I have some ideas, but I got to apply the same standards in what I argue to you that I expect from you. So I can't answer that because I think it would require improper speculation on my part.
Thank you. Commissioner Whitfield.
Thank you, Mr. Chairman. I have some questions for each of you. And Mr. Ham, when I get to you in a minute, I'll try not to cause you to do anything you think might be improper, but I'm going to go a little bit down that same path with you. But first, Mr. Ellaby.
Just out of an abundance of caution, I certainly hope my comments were not intended as a criticism of the commission or Commissioner.
Certainly, no, sir. Not. I'm just going to push that issue a little bit about the town.
I wouldn't be concerned about you doing that either. And if it comes up, I would have the same answer, and that answer is offered respectfully, not with any attitude behind it.
Yes, sir. That's well taken. Mr. Ellaby, the other questions are going to be to both of you, but just this one to you. I'm going to go where Judge Irvin went just a little while ago about the certainty argument. and with all due respect, I realize you brought that up, but don't you see, my question to you is, don't you see that possibly as apples and oranges, whereas in the certainty situation, the ratepayers were obligated, the company was obligated to pay certainty up to $50 million to meet the terms of the contract, and with the contract, with the coal production and coal generation totally declining because of federal regulations, could not meet those obligations. And that was just, as Judge Irvin said, that's a business decision because of drastic change in federal policy and the generation from coal. So that was a business decision made. And here we're talking about litigation about other situations dealing with government, not contractual in nature, I guess is what I'm trying to say. So I do see, do you not see those two as being apples and oranges, so to speak?
Well, maybe they're
Or an unfair comparison,
Granny
maybe.
Smith and Red Delicious. There are lots of similarities. The reason I cited the Commission's ruling in the DEP case on reconsideration was that ORS took a narrow view. You got a bad decision in the summary court, in the business court, and then you had to settle, and therefore you shouldn't recover. Very similar to the argument they're making here.
So you're using the broader view argument.
And instead, this commission, in my view, took a more appropriate, broader look at the whole terms and circumstances leading up to the decision in that case, and determined that the company had appropriately defended itself in the litigation, then appropriately settled, and it was business decisions. And that's what CWS has done here. They understood the law, or thought they understood the law, as the South Carolina Supreme Court ruled, and were guided by that. And this commission's ruling in 2003, and Judge Seymour took a different view, but that doesn't suddenly mean that everything they did up until that point was unreasonable or imprudent.
Okay, so thank you for that answer, Mr. Ellaby. Mr. Ham, I got a couple of questions for you, and then I guess maybe a general for both of you. Mr. Ham, about halfway through your original argument, you cited some figures that were paid by the company. You talked about the $23,000 in fines. I got that down. And then you talked about $300-something thousand that was paid to Central Midlands Council of Government, the COG.
Yes, sir, a total of $350,000 that had two components. $250,000 to the Central Regional Council of Governments, and then another $100,000 to a COG program specifically addressing how they implement and enforce the Section 208. So that you have a sense of comparison.
So $250 went straight to the COG, and
Another 100 went to a related program for a total of
208
$300,000.
plan.
Attorney's fees of $385,000 paid to Congaree Riverkeeper, then the $23,000 penalty imposed by Judge Seymour, and directed that payment be made to the federal treasury, which was ultimately done. So just to give you the comparison,
yes, sir.
Instead of $1.5 million, and remember I told you that she agreed to a request for the party. She would set aside the $1.5 million penalty, and she was going to have oral argument and submissions. The parties ended up entering into a settlement. But what ratepayers are being asked to pay for is that CWS reduced the $1.5 million penalty. They paid the legal fees that the company used to get the penalty reduced to $763,000 when they never had a responsibility. all that work was solely on the behalf of the owners of Carolina Water Service. No matter what the number was, ratepayers are never going to pay for it under your own policy rulings. You don't pay, ratepayers don't pay fines and penalties, which brings us right back. So what they're saying is, we want you to pay our lawyers for all the work they did to help us avoid paying $1.5 million, instead only pay $763,000. We're going, it's ORS's policy position. Well, that's doing indirectly what you said they shouldn't do directly. The only beneficiary in that was the owners of Carolina Water Service, not ratepayers. Ratepayers didn't get a benefit of reducing any of those dollar amounts because they were never subject to them to begin with.
Let me, if I might, just do a little recap with you.
Of course.
So you're saying the company paid the Riverkeeper, Congaree River, $385,000.
Yes, sir. That's
and their legal fees.
Yes, sir.
Total of $350 to Central Midlands COG, with $250 going directly to the COG, $100 going to the COG's 208 plan.
Yes.
And then $23,000 in fines.
Yes, sir.
Okay. And just to kind of, again, recap, the Riverkeeper, in your statement, your opinion, Riverkeeper, when they brought suit to condemn the facility because the company wouldn't do it, nor would the town of Lexington.
No, that is not what they did, and in fact, I disagree with the statement that Mr. Ellerby made. No. Mr. Stangler said their goal was to get them to reconnect, and if you'll look in the...
But to do that, they had to condemn the facility.
No. But what the Riverkeeper lawsuit under the Clean Water Act was intended to create a legal inducement that Carolina Water Service engage in legal steps that it had not done before to begin the process to get their plant interconnected. They were not attempting to condemn the plant, and Mr. Stangler, on direct testimony, said, no, it was never our intent to shut down and condemn the plant and cause that plant to shut down. That is absolutely false, and that is unrefuted in his direct testimony. He's the one that brought the lawsuit.
All right, well, let's just, back to the 2A. You got the Federal Clean Water Act, which you cited heavily in your original argument.
This whole lawsuit was under it, yes, sir.
And that comes down, when you have the Federal Clean Water Act and get to state level, DHEC is the agency that carries out those federal EPA or clean water laws, regulations.
Forces the standards.
Forces the standards, yes, sir. And then under the 208 plan, when you get down into the weeds of it, it requires there to be a DMA, designated management agent.
Yes.
And in that 208 plan, that's the town of Lexington as a regional DMA, right?
Well, it's part of the 208 plan is what they call the overall plans that apply to water systems all over South Carolina. It's not unique to the Midlands. And 208 is a reference to a section in the statute, but it applies statewide. But what the $100,000 in the settlement was directed to allow them to continue to do a better job of, getting compliance under the 208 plan, because what the discharge limitation violations were the violations under the limits established under the National Pollution Discharge Elimination Permit under 208.
So, but under that 208 plan, it still designates as the DMA designated management agent as the regional entity as the town of Lexington, right?
Yes, for purposes of the interconnection required to the regional system, the facts in the law before the commission today deals with Carolina Water Services' failure to timely take appropriate actions to induce an agreement to interconnect. But that you're correct, that involved, there's two parties to that issue. That is actions required by Carolina Water Service, actions required by the town of Lexington. Yes, sir.
And Mr. Ham, I'm going to go kind of back to where Commissioner Williams was. Sitting here on this commission, the town of Lexington is not a party of record. So we're having to rely heavily on your arguments, your testimony, and previous proceedings here. I just remember overall, not specifically, there being a lot of reluctance, difficulty, whatever word you want to use, for years for that to happen. And I'm back to Commissioner Williams' question, and I'm not trying to, that's what I meant about, I'm not trying to push you over the edge into something you feel improper, but
Ask whatever question you think's appropriate, that's your job.
whatever, how much obligation, obviously they had an obligation under the Federal Clean Water Act and the 208 plan, how much obligation, responsibility, liability, whatever word you want to use, rests with the town of Lexington in your mind?
Well, that's the organization to which Carolina Water Service had to interconnect, but and again, ratepayers are being asked to pay the legal expenses associated with this federal lawsuit. The federal lawsuit basically ascribed the difficulty and the delays on the failure, in quoting the court, for them to act in good faith. And to have a contract, you have to have two parties. And what the federal court said, one of the key parties, Carolina Water Service, was not pursuing the contract in good faith. The record, I have nothing that I can say about the town of Lexington that is in this record, but when a federal, as a result of a lawsuit under the Clean Water Act, says that a party was not proceeding to act in a way in good faith to create and induce an opportunity for an interconnect, it takes two to tango, and in this circumstance, the federal court found liability because it said that Carolina Water Service did not act in good faith, did not enter into the dance trying to listen to the music, and our position is simply fine, but ratepayers don't need to pay all their legal fees for their failure to do that.
And that's what we're here to discuss, is the legal fees, and I'm not talking about the fines part, but the part, of course, you just answered it, I guess, citing that you're claiming the company didn't act in good faith to try to get that agreement going, is your assertion, right?
Yes, and again, I want to be very clear. What are we relying on? They want to collect close to $500,000 in attorney's fees in a case that they lost because the court found liability. They entered into a settlement and they ended up negotiating. The company lawyers on behalf of the company, not ratepayers, negotiated a $1.5 million penalty down to $763,000, none of which benefited ratepayers, and our attitude is that they don't pay for it. Can I insert something before I forget? There was reference to the DEP case that you asked. Can I address that?
Yes, sir.
The certainty case is not remotely relevant to the matter now in front of you. Here, there were no fines. There was no penalties. There was no allegation of environmental violations. Duke Power did a lousy job of negotiating a contract, which is what the business court judge said in North Carolina. They presented people that couldn't even explain the contract that they delivered. So our objection for certainty is not burdening ratepayers when the business court in North Carolina, and it's an 81-page decision, and I'm sure you probably read it, is extraordinarily details on the ongoing failures of Duke in that case. And I'm not here to argue Duke, but my point being that reference certainty is not an appropriate comparison. It is not remotely similar. That case just rises on the fall that Duke Power did a lousy job of negotiating the contract, and ratepayers are bearing the brunt of it. We argued against it. This commission has indicated that they think ratepayers ought to pay for it regardless. And you haven't issued that order, and it's not appropriate for me to. That's what you've indicated you're going to do, but until we see an order, it's not appropriate for me to comment further. What else can I do for you?
That's all I have, Mr. Ham. Mr. Chairman, that's all I have.
Thank you. Commissioners, any other questions? All right, we're going to take a break then. Okay. Then continue for 30 seconds, we'll let you go, Commissioner Howard.
Either one of you, over what period of time were these 23 violations? And what was the date of the last violation?
I can answer that. Generally, it was over the period of 2012 through, I think, 2014, and the last violation was either late 2013 or 2014.
My understanding, it's a longer period of time than that, Mr. Commissioner, but I'd be glad to do some research on that and go back through the record and find, and see if that's in the record and submit something after running it by ORS. We'll try, we can do that together.
And the last question is, in the case, 2002, 147, the commission ruled that there would be excessive rates. What percentage of rate increase would that be for the customer? What would consider excessive rates then?
I am not in a position to answer that question. I just know the commission expressly stated that the rates were too high and they were not going to approve it.
I can, if you give me a few seconds, I think I can find that. It was a substantial increase. I think it may have doubled the rates, but it's in that order.
Well, I could check it out. I just curious. I thought you might have right offhand. I don't want to alienate my supervisor. And
that order, I'd recommend it. It gives some analysis of the way that Lexington did its cost study to come up with its rates. The commission did a good job of explaining why this commission found that proposal by the town was unfair. Thank you.
Thank you, Commissioner Howard. Any other questions? Okay, Mr. Minches, I think you need to do something.
Yes, sir, Mr. Chairman. Thank you. Is November 4th an acceptable date for proposed orders?
Yes.
Thank you.
Okay.
Whatever the commission requests, we'll be happy to meet that request November what day is that?
That's a Monday.
Okay. No, that's fine.
Okay. Anything else to come before us? Not, thank you everybody for being here, and we're adjourned.